The next case is Green Tree Servicing versus Wells Fargo. How much time would you like for rebuttal?
5 minutes, Your Honor.
Okay, whenever you're ready.
Good morning, Your Honors. My name is Michael Ruff. May it please the Court, I represent the appellant. Your Honors, this is a case where my client, Green Tree, brought a declaratory action to have its mortgage, for the benefit of the doctrine of equitable subrogation, to have its mortgage equitably subrogated to that of Wells Fargo and to the persons who took title from a Wells Fargo foreclosure down that chain. The case went to summary judgment. There were competing summary judgments. My client's summary judgment was denied. Wells Fargo was granted. The court found that there were no material facts in dispute, which is the standard for a summary judgment.
Do you agree with that?
I'm sorry?
Are there material facts in dispute here?
Yes, Your Honor, we are. Our position is that there are material facts in dispute such that Wells Fargo summary judgment should not have been granted.
You were asserting in summary judgment there's no material facts in dispute and we ought to win. They're saying there's no material facts in dispute and they ought to win.
Correct.
But despite that, you agree that you
as
now
stated,
say there's material facts
correct,
in dispute.
Your Honor. We did file a summary judgment motion, but in the context of how Wells Fargo motion for summary judgment was filed, that there are disputed facts.
What are those facts in dispute?
Specifically, if you'll forgive me, it's difficult to fully separate what the disputed facts are from the doctrine of equitable subrogation, because it's the facts here that go into why equitable subrogation should be applied. What the background underlying here is there was a mortgage in favor of Chase, and forgive me, I'm going to use shorthand for the purposes of time. Chase had a first mortgage. Wells Fargo had a second mortgage, which was a line of credit, and my client, Bank of America was the original lender. My client was assigned the mortgage. Bank of America gave a refinance loan on the property, refinancing the borrower, a person named Brachia, who was
They paid Chase, and then they paid Wachovia. But Chase gave them a satisfaction of the mortgage. Wachovia, because that was a draw. I mean, they could continue to draw on that mortgage, and there was no request for satisfaction. So that mortgage remained outstanding, and they in fact did draw on it, and I suppose didn't pay it back, which is why they filed the foreclosure complaint.
Exactly, Your Honor. And the line of credit, the Wells Fargo line of credit, or it was Wachovia, but then it too was assigned to Wells Fargo, correct. It specifically provided that the borrower must terminate the loan. The borrower must request for the line of credit to be closed out.
Which they didn't.
Correct.
Okay,
correct.
so that's not in dispute.
Correct. They did not. Well, one of the facts that would be in dispute is the actual Wells Fargo summary judgment in one page of the motion declared, and the line of credit backs this up, the actual text of the line of credit says the borrower must close the line of credit. Wells Fargo summary judgment says that, motion for summary judgment says that, and then a couple of pages later in the same motion, they blame Bank of America and by extension my client for not closing it out. So on the one hand, that's a disputed issue, material fact within the motion itself, that whether it's the borrower's obligation to close it, which the line of credit says that it is, or whether it's my client's obligation to close it, or Bank of America. The judge's summary judgment order adopted.
Why does it make a difference who was required to close it? The fact is it wasn't closed.
Correct, and that's why it's difficult to extricate the facts that are in dispute versus the equitable subrogation aspect, because equitable subrogation says, the doctrine says that equitable subrogation can lie even if a mistake was made. The line of credit wasn't closed out. It should have been closed out. But the Godwin cases, the Sinchuk case, the Riverside case, and the Fishbein case, which is cited to extensively by the Riverside case, all hold that equitable subrogation is there in a way specifically because mistakes are made. That
Well,
the whole
doesn't, but equitable subrogation isn't like a self-executing, it's an affirmative defense, is it not?
it is a defense, yes, Your Honor.
And an affirmative defense needs to be raised, and it was not, was it?
It was not, but that's because my client was not a party to the action.
Well, your client technically, well, Bank of America was a party to the action initially.
Bank of
And
America was-
when Green Tree, I guess, took over for Bank of America, I mean, they became aware of this action, correct?
Not that I'm aware of, Your Honor, no. My client, and forgive me, Bank of America, Green Tree, Wells Fargo filed their foreclosure and named Bank of America. Bank of America was served.
And they didn't respond, and didn't they get defaulted?
They got defaulted, Your Honor, but not until after there was a recorded assignment of the mortgage in question from Bank of America to my client, to Green Tree. Bank of America was not defaulted in that case until after that recorded assignment of mortgage. But then furthermore, and more importantly, Wells Fargo never recorded a lis pendens until 4 months after the transfer of the mortgage to my client, to Green Tree. And Section 48.23 of the lis pendens statute is very clear on this aspect. And if I may, I'll just quote, this is from subparagraph 1A, and also subparagraph 1B2, but as to 1A, an action in any of the state or federal courts in this state operates as a lis pendens on any real or personal property involved therein or to be affected thereby only if a notice of lis pendens is recorded in the official records of the county where the property is located. And subparagraph 1B2, any person acquiring for value an interest in the real or personal property during the pendency of an action described in subparagraph 1, which I just quoted, other than a party to the proceeding or the legal successor by operation of law or personal representative heir or devisee of a deceased party to the proceeding, shall take such interest exempt from all claims against the property that were filed in such action by the party who failed to record a notice of lis pendens. My client Green Tree is not a legal successor by operation of law to Bank of America. They're the assignee of a mortgage. There was a conveyance.
Let me ask you this. Assuming that we agree with that they should have done the lis pendens before, you weren't on constructive notice. The problem I have is in August, when you all got the assignment, if you did a title search, it would have said you were second, right? By time factor, that
By
the
virtue of
Wells
recording,
Fargo's
yes, sir.
predecessors' mortgage would have been recorded before Bank of America's. So if that's the case, you know you're second, and the ultimate outcome from the trial court's decision is that you're second, so you're no worse off than you thought you were back in August of 2013. Alternatively, if you had looked at, gone outside of the public records, the recording, what's recorded, and looked at Bank of America's records, maybe you would have seen, hey, we got a claim for equitable subrogation. But then there was no, after that there were 2 judgments, 1 vacated judgments, 3 or 4 people owning the property. Why did this is an equitable claim you're making, and it's 3 years before y'all file the action. I mean, should we factor that in deciding whether, equitable relief is required here?
Well,
I mean, that's my concern, as I sit here reading your
understood.
brief and reading their brief, because I'll tell you, I'm not impressed with their argument that you all had notice of the lawsuit. I mean, I don't know why they took 6 months to file the lis pendens. But this is the part that bothers me, is you all wait 3 years, and there's all these things going on with the property. So that's my concern. So
Understand, Your
can
Honor.
you alleviate my concern on that?
As best I can, I will try. Equitable subrogation is a defense, yes, but it can also, as we have done, be brought as a separate action. The whole point of equitable subrogation is that it is to leave parties in no worse position than they should have been in the first place. As they should be in no worse position as they would have been had the payment, which is essentially what is being sought for equitable subrogation, had never been made. Wells Fargo's mortgage was a second mortgage. Undisputably, it was a second mortgage. The payment, they were second to Chase. My client, or Bank of America rather, paid off the Chase mortgage. Chase mortgage was satisfied. At that point, Bank of America and then Green Tree, because of the assignment of that mortgage, stood in the shoes of Chase. Wells Fargo was and should have been, from for forever, a second mortgage. What has happened by not allowing, despite, I understand 3 years have gone by, but by not allowing equitable subrogation, what is, as in fact has happened, is the injustice, if you will, is that Wells Fargo has gotten an improvident jump in priority. My client, or Bank of America, paid, I believe, their loan was $116,000. It was a refinance loan. They paid off the Chase. They paid the Wells Fargo down to zero. Wells Fargo got the benefit of my client's predecessor, Bank of America's, money to the tune of approximately $50,000, and Wells Fargo now has a jump in priority to first place if
Bank of
equitable
America
subrogation is
didn't
not applied.
add Wells Fargo into their foreclosure complaint.
I'm sorry, ma'am, I'm sorry.
But Bank of America, but where Wells Fargo had Bank of America as a party, that was not the reverse, correct?
Correct. And as to why Bank of America did not name Wells Fargo to its foreclosure, I do not know the answer to that. I do know that...
You wouldn't typically name the person who was the first party, right?
Correct. You wouldn't typically know. No, ma'am.
So only if there was a junior lien holder.
Correct.
So
But
that could be a
the
reason
Bank of
why.
America final judgment foreclosure was ultimately vacated. And so in our position would be is that our mortgage still exists despite, because of equitable subrogation, because the final judgment in the Bank of America foreclosure was vacated, the mortgage still exists. So, and the appellee makes arguments that we are trying to impose this lien on the property. Our position is that the lien's not being imposed, it was always there by virtue of equitable subrogation, because there has been no satisfaction of our mortgage, and because Wells Fargo got the benefit of this jump in priority as well as the $50,000, but that's...
Bank of America's judgment was vacated upon the motion of the party who purchased the subject property at the Wells Fargo foreclosure sale?
Correct.
Okay, so...
And again, to the question
What
of,
should we glean from that? How about that?
to the question of why this is coming out now after 3 years, Your Honor, I'm trying to, as best I can, explain.
I know you weren't the guy.
Correct. I mean, ultimately, why this wasn't brought up on day one, I can't answer that. It should have been. I don't dispute that. But the point is that equitable subrogation is to make sure that the parties are in no worse position than they would have been. No, it's to, if you will, it's to maintain the status quo. Nobody is any worse off, but likewise, nobody gets
But
unjustly
this third
enriched either.
party is, there's also that exception where if it's going to work an injustice to a third party. I mean, you have this third-party purchaser who's purchased this property, who's invested in this property, and is going to lose that. So that's certainly something that appears to be what the trial court
And-
ultimately considered. I think that if Bank of America and their foreclosure complaint had initially listed Wells Fargo or Wachovia as a defendant in their lawsuit, then both parties would have been on notice, and there would have been an alert. Hey, wait a minute, we got the same property here, we're suing. And so there was another mistake that happened where they weren't sued. And so you've got these two lawsuits going on the same property in two different places at two different times, and nobody, it's like the left hand doesn't know what the right hand is doing, or, you know.
Correct. And again, mistakes were made. And it's not,
But
there's
that
a
tie-
lot of what should have been done, but
That ties into what Judge Evander was saying earlier, though. Is, okay, Miss Ray, who now is the owner of the property, who you want to basically say, well, I know you paid 80-some thousand for it, but guess what? There's a 60,000 or whatever the amount of the lien is going to go get tacked onto that. She's looking and says, okay, I have a final judgment in the Wells Fargo case that says Wells Fargo's lien is superior to all defendants and anybody who claimed by, through, or under them. All right, which she, you could, talking to your lawyer, could say, well, that would be Green Tree. And then, then you add on to that, Green Tree's final judgment, the judge sets it aside. So, there's two things going in her mind, I would think, saying, all right, somebody seems to be saying that Green Tree's claim is not at the top of the list here, so I'm going to buy because I don't think Green Tree's involved. And then 2 or 3 years later, or whatever the amount of time is, Green Tree hires smart lawyers and says, hey, you guys really got stiffed on this. Again, Ocalisms here. You guys got stiffed on this, and we need to bring an action because what's right is right, and we had priority. That seems a bit unfair to Miss Ray to rely on judgments and orders signed by judges and then come back years later and say, you got to pony up another 60 if you want a clear title.
Well,
Is that kind of a non-verbose legal way of me saying what's going on here?
well, if I may, Your Honor,
Close?
specifically, yes, sir. It's a non-legal way of saying what's going on here.
Basically, it's a way of asking, how is it not an injustice to her?
Correct. Yes, ma'am.
Or no, in Marion County, it ain't right. How about that?
To a certain extent, the whole fact of whether or not there's an injustice to a third party, that is part of the issue that is within this case, within this appeal, as far as the doctrine of equitable subrogation. In the Dade County versus the radio station case, it laid out 5 purported elements for equitable subrogation. The 5th one of which is what the court said is at issue. The 5th one being that no injustice shall suffer to third parties. However, that Dade County case and the other cases which cite to this 5-element structure, the 5th one being no injustice to third parties, are all in the context of tortfeasors, personal injury, insurance companies subrogating one to another. In cases where it is mortgages that are where equitable subrogation is being discussed, Sinchuk, Fishbein, Riverside, those cases all simply say no injustice to other lienors, because that is what you're trying to establish. There's no injustice to other lienors because Bank of America paid off Chase, stood in the shoes of Chase. Bank of America paid off, or paid down rather, the Wells Fargo. So therefore, under the Sinchuk case, which established what is the injustice to lienors, is that my client would have equitable subrogation to the extent of the money that they paid.
Let me ask
As
you
to
this.
injustice,
Let me ask you this. Assuming that Ms. Ray is an innocent party here, and neither your client nor Wells Fargo are innocent parties because they both messed up and there's all these other factors. If we ruled your way, does Ms. Ray have a cause of action against Wells Fargo?
I believe she does, Your Honor.
And what cause of action would that be?
And I was to the point of injustice as to Ms. Ray, whereas we were saying we don't think injustice necessarily is a factor based on what the case law says, but if it was, she has not suffered an injustice because she has a number of remedies available to her.
Spend more money to hire a lawyer
She
to
can
go
sue.
out and...
Well, title insurance, if she has it, I worked for a title insurance company as in-house counsel for 7.5 years. She would have a Class A title claim if she has title insurance. She can sue upon her warranties of title. She received title via a corporate warranty deed.
If she got a tax sale, where does that put her?
I'm sorry?
If she got a tax sale,
She
where
did
does
not
that
get it at
put
a
her?
tax sale. It was a
But she
corporate
bought it from
warranty.
someone who did get it at a tax sale.
Correct. And furthermore, as to injustice to Ms. Ray, our action was filed prior to her taking title. So to a certain extent, where was her due diligence to check the public records to see has something been filed? One of
Well into your rebuttal time, I just want to let you know that.
I understand. I think this is an important
Okay.
point to make. She took title during the pendency of our action. One of her predecessors in title, the current owner at the time we filed our action, was named to that action. So the appellee wants to impute knowledge of the Bank of America being sued by Wells Fargo and the Wells Fargo's foreclosure. The appellee made an argument to say, well, our list pendants was recorded after the assignment of mortgage to you, Greentree, fine, whatever. You have actual knowledge because your predecessor in
Let me ask you this.
Of the
If
mortgage
Ms. Ray
title.
had gotten the property at the tax sale, so there weren't all these other people in between, but she just got the property at the tax sale, and then all this came out, would she have a cause of action against Wells Fargo?
This wouldn't happen if this was a tax sale. A tax sale wipes out all prior lienors.
Well, they foreclosed, right? Wells Fargo foreclosed.
Correct. This is a Wells Fargo's foreclosure, not a tax deed sale. If it had been a tax deed sale,
Well, okay,
then,
foreclosure sale, I'm sorry. So if she got it at the foreclosure sale, would she have a cause of action against Wells Fargo, because the title wasn't good or whatever?
I mean, it's speculative, but I would think so. I mean, her title derives through Wells Fargo. Wells Fargo was in second position. Under equitable subrogation, Wells Fargo should be no worse off, no better off than they would have been had the Chase payment never been made. And the problem is that as of right now, Wells Fargo and everyone in their chain of title now has a jump in priority, has received a windfall, as it were. And I'll reserve.
Save your 20 seconds?
20 seconds, yes, ma'am. Thank you.
Good morning, Your Honors. May it please the Court. I'm Dean Morandi here on behalf of Wells Fargo. Here with me is Michael Rocha on behalf of Denise Ray. I'm going to be arguing for the co-appellees, but if you have any questions specifically for counsel for Ray, Mr. Rocha is here to answer the questions. I'm just going to give a real short background. I think the Court has an understanding of what's going on here, but just to make it crystal clear what we're talking about. In 2013, Wells Fargo filed its foreclosure action, naming Bank of America. April 2014, Bank of America got its foreclosure judgment foreclosing out all inferior liens, including Bank of America. And this property was sold. It was sold 3 times. 2 years after it was sold the first time, Green Tree comes in and says, wait a minute, we should be equitably subrogated to a superior position, and we want to impose a lien on the property. Equitable subrogation is not available in such a circumstance, which is why Wells Fargo moved for summary judgment, showing prejudice to Ray. Trial court agreed, granted summary judgment. Now we're here on appeal. They made 2 arguments in their initial brief as to why they believe the summary judgment was improper. The first argument was that, well, Ms. Ray is a third-party purchaser, but under Florida law, equitable subrogation is only concerned with lien holders. We don't really care about innocent third-party purchasers. Well, we've demonstrated, we've probably cited more cases than we need to, at least a dozen cases holding that it applies to innocent third parties. And you've got the final equitable underpinning of what equitable subrogation is. It's an equitable doctrine. Obviously, it would be inequitable to impose a lien of $60,000 plus that wouldn't otherwise be there. So that's argument number 1. The only other argument they raised is whether the summary judgment evidence really showed that Ms. Ray would suffer a prejudice. For example, they argued that, well, Ms. Ray attested in her affidavit that she paid $87,000 for the property. But hey, if you look at the deed, it says the consideration was only $10.
I think every deed says consideration.
And that's exactly right, and that's what they even conceded in the lower court. So we don't have an issue of material fact there. The other argument they said was, well, you look at her affidavit, she says she put this money into the property, she paid the taxes, she paid the upkeep, she's going to lose her investment in the property. They said, well, that's not competent evidence. I'm not sure where that comes from. Clearly, that's competent evidence. Property owner can clearly testify to that.
Let me ask you this. The trial judge said, and you all argued on appeal, that one of the grounds to grant the summary judgment or another factor is that they didn't bring it up in their prior case. I'm kind of baffled why no lis pendens was filed at the time Wells Fargo filed the complaint. Are you still maintaining that they had that they were under an obligation to bring it up in the prior suit when they weren't a party and they weren't given?
Oh, absolutely, absolutely.
Well, they weren't a party, right?
I do not agree with that at all.
How are they a party?
They were served with process. And they were served with process when Bank of America still owned this mortgage.
Where in the record does it show that they were a named party or served process? Bank of America was, but...
Right.
But how about Green Tree?
Bank of America.
Well, I'm talking about Green Tree. That's the whole purpose of the lis pendens, is to put someone else on notice that there's a lawsuit going on.
That's exactly right. Let me answer your question in putting it this way. Their argument fails, this lis pendens argument that we're hearing about now fails for several reasons. First, I don't see that anywhere in the initial brief. So that's one reason why we shouldn't even be talking about it now.
No, the trial judge raised it. You raised it in your answer brief as a basis to affirm the summary
That's a
judgment.
tipsy coachman
They replied and said, no, that's not a valid argument. So it is before us.
Well, here, this is how the argument goes for them. Yes, we were named in your judgment. Yes, Bama was named yes, Bank of America was named as a party. And yes, there was a judgment against Bank of America wiping out their inferior lien, but you didn't file your lis pendens until after Bank of America assigned it to us, so that means that the judgment doesn't apply to us, and therefore that means that Ms. Ray wouldn't suffer prejudice because the lien should have been there the whole time.
Well, I understand the last part is an addition, but how about up until that last part about Miss Ray? I mean,
Well, yeah,
you sue someone, in the meantime, they assign their interest, there's no lis pendens, and then you prevail against the person you sued. How is that a judgment against them?
well, they have a judgment against, because that's a judgment in the interest. You don't have an obligation to constantly update your lawsuit. I think we have a little bit of a disconnect as to what it means to file.
But that's the whole
lis pendens.
purpose of filing the lis pendens. You give everyone in the world notice.
Right. And could it have been filed earlier? Yes, it certainly could have. But that
Should
doesn't
it
mean-
have? And doesn't the statute say that if you don't, then it doesn't give notice to everyone in the world?
It doesn't give notice to anyone in the world, but because Bank of America had notice, if they want to go after somebody, they can go after Bank of America. But that doesn't mean that their interest is wiped away simply because you didn't file a lis pendens. And there's cases that say all lis pendens does is give constructive notice to the world. They took Bank of America's interest. They stand in the shoes of Bank of America in terms of their assignment. So not having a lis pendens doesn't mean that it doesn't apply to them whatsoever. And again, this is an argument that doesn't have actually anything to do with the issues that they raised in their initial brief, in my opinion. Obviously, the court may disagree with that to some
I mean,
extent.
the purpose of the lis pendens, sure, they could win against Bank of America for not disclosing something. But the whole idea of the lis pendens is that they win against you if you don't have a lis pendens, as far as the issue of notice, and you win against them if you do have a lis pendens. That's the whole purpose of the lis pendens statute.
To a certain extent, it is not the law of, I don't believe it's the law of Florida that if, for example, use the parties here, Wells Fargo sued Bank of America, and then right before your final judgment got entered, if Bank of America tries to give away their interest and they hadn't filed a lis pendens, then all of a sudden that third party is free and clear of that judgment. I don't think that's the way this operates in terms of a lis pendens. A lis pendens is, all that does is give constructive notice. It doesn't mean that the interest that Bank of America had wasn't wiped away. But again, we're getting a little far afield of what the actual arguments raised on appeal were. This issue is tangentially related to our tipsy coachman argument, which was they had to raise this, they being Greentree or Bank of America, had to raise this in Wells Fargo's foreclosure action to be able to.
Well, you raised two arguments as to why they lose. You said, one, Miss Ray gets affected, and two, they had notice of the lawsuit, or they should, and they didn't respond in the prior lawsuit brought by Wells Fargo. Well, you've raised two arguments. I'm having trouble with one of them. That's all I'm telling you. So, but to say that it's really not an issue, you raised it as an issue.
No, I understood. As far as the tipsy coachman argument goes, fair enough. But again, let's go back to the actual issues that they raised, which relate to.
Bank of America did not respond to the lawsuit, correct?
That is correct.
So Bank of America, if they believed that they were equitably subrogated to the Chase mortgage, then they should have filed an answer and affirmative defense to your lawsuit.
I think that's absolutely right. I mean, I think the court's characterization is pretty much exactly what happened. Later on, somebody got hired who knew what they were doing and realized that they had potentially an equitable subrogation claim.
Bank of America at that point didn't care to spend more money to raise any
Perhaps
defenses.
that's true.
because
Perhaps that's true. 'Cause
they-
let's
they-
go back and look at exactly what happened here. The property was sold for $26,000 back for Wells Fargo's judgment. They had a judgment for more than 60. They lost money on this too. There's not exactly a whole lot of money going around that would have been paid based on these liens. So
But you all elected not to bid higher than 27 or 6,000 at the foreclosure sale, and
exactly.
apparently somewhere down the road, somebody paid 82,000 for the
Right, and
property,
that's
which
because
would have
of
satisfied
improvements,
your
the
judgment.
real estate market is getting better. Again, it actually looks like they're getting they're starting to see, the improvements on the property and the value going up, and they're like, hey, there might actually be some money in this property now, 2 years later, that it might be worth doing this. Well, that's not what equitable subrogation allows for. It's been 2 years. It's been sold at least 3 times. And at no point would anybody coming in here say, well, there's no prejudice to imposing a lien that could be foreclosed on against a property against a person 3 people down the chain in a title. Now, interestingly enough, we heard something that I had never heard before. I thought, and I was giving them credit for not suggesting that they didn't actually have notice, being Green Tree, that they didn't actually have notice of Wells Fargo's foreclosure action, because clearly they had notice. They had actual notice. We're talking about Liz Pendens gives constructive notice, but Bank of America, at a minimum, had actual notice of the lawsuit on what we're talking about here. So it doesn't seem to make sense to me when they know about it. And then when it was filed in December, when the Liz Pendens was actually filed in December, there could be no question that the world had notice at that point. And they still stood on their rights for still over 2 years to do anything about this. So if we want to talk about a Liz Pendens, it was filed in the case. It just wasn't filed until later. Okay? They knew about this. And again, we're talking about equitable subrogation. To the extent
You'd agree that if you acquire property in August, you're not under any obligation to check every day, as long as you own that property, to see if anyone's filed a Liz Pendens against it. I mean, as a practical matter, it comes up at closings and things, lawsuits, things like that.
I suppose.
I mean, I don't know if you're a homeowner, but if you are, when's the last time you checked to see if there's a Liz Pendens against your property?
That's a good point. That's a good point. But again, I think I'm talking as a practical matter. Given that everything that was going on in this property, I hadn't heard them say until just now. We heard an intimation by opposing counsel suggesting, well, I don't know if Green Tree actually knew. I thought it was pretty much understood at this point. Clearly they knew. There was litigation going on. It was just the decision was made at that point. Well, I guess we're an inferior lien. Why in the world would we spend money to do anything about this? Until over 2 years later, when they realized, hey, there might be some money in this property, so let's go through this process. Let's impose a lien on an innocent third-party purchaser 3 people down the line to see if we can get equitably subrogated to a position of priority. That way, we can foreclose and try and get our money on this property that's now actually worth something based on the improvements and the increase in the real estate market. Equitable subrogation doesn't allow for that. And unless the court has any additional questions.
Any more? No questions?
Okay, well, in that case, thank you. We would respectfully request that the court affirm the judgment in this case.
I'm gonna have to talk fast.
Thank you, Your Honors. May it please the court. Very briefly, the industry standard for title, for conveying title, is that when you file a foreclosure action and then your Liz Pendens is recorded, you should do a gap update. They call it a gap update to check the status of title, to make sure nothing has come in from when you filed your suit, from when the Liz Pendens is recorded. That apparently was not done. Injustice would suffer to Green Tree if this is not reversed.
Thank you.
Thank you, Your Honors.
All right, we're gonna take a